why we have the COVID page for all these.
So the meeting's on.
So you got 2 participants.
Bob, it looks like you're muted. Can you hear us?
I'm okay. I think I'm okay now.
Yeah, we hear you.
And you said Chuck's not going to be attending, you didn't think?
I'm not sure.
Okay.
Where the hell are you, Bob?
That's Beijing behind me.
Good morning, everyone. We'll start the meeting. Today we're going to be discussing the zombie homes and short-term rentals. And I've asked Doug and Chris to come into this meeting because information we can obtain from them, and they'll be the ones that more than likely will be implementing any information that is needed to get these codes on the books. So we will start with short-term rentals, and I'll turn it over to you, Doug, to let us know what your thoughts on it are, and then we can discuss it. We have discussed it several times in different meetings, you know, and we've had the 2 companies come in, and one on the Zoom and one in person.
We've been talking about it for over a year. The most recent version I saw of this local law was actually dated October the 9th of 2019.
That's right. Listen, the COVID has really held us back big time.
Let's go with that. Okay. I think one of the things is, truthfully, I don't mean this being to any of you guys, I think you're getting lost in the weeds with the operations of it. Don't worry about that, is what I would say. That falls under me. I'll worry about that with code enforcement on the operations side. You guys stick to the legislative branch, that's what you are, and the actual law and what's in it. And what I've done is, and I know I didn't get this when we did this, but I'll circulate this around. I took your law that you had the last time, some that way, and really just simplified it to a registration. Whacked a bunch of it out. So basically what it is it would be a short-term rental, and Bob, I can email this out to the ordinance committee so you guys all have it. So what it would be is just a short-term rental regulation section of the code 220-9, and it takes it basically down to completing an application that includes the address, the contact information, acknowledgement, certifying that the regulations, that the state building code regulations are all there. If not, you're in violation of 220. Doesn't call for any type of inspections or anything. Just real simple here. The term of the permit would be 1 year, and then once we get a complaint, just like we do now, once we get a complaint, we go investigate that, and if it's found that you don't meet the building code or the town code, then it begins the process of violation and remedy for that. And you're in violation of your short-term rental permit. So really just trying to simplify it.
Kind of where we ended up last time. The only question there we got to was, are we going to hire a third party to find these
That's on the operations side.
SDRs?
Let me worry about that.
Okay.
Okay.
You decide who's going to.
Well, the town board will ultimately
who's
decide.
going to collect
I'll
the
look
fee.
at that and all
That
that
was
stuff.
what
Right.
we were talking
Right.
about.
Yeah.
So the only 2 things I had on this one was you wrote or a portion thereof
Where do you see that?
under nightly short-term rental.
What sections, Chris?
The definitions.
229.1A3.
So if you rent a portion of your house, it's no longer a single-family dwelling; it's a multi-family dwelling. So we should probably avoid that.
Like even if it was just like you have a 4-bedroom house and you rented 1 room out.
You are a multi-family dwelling.
You just
A
leave
boarding
it,
house, a hotel, motel.
You just leave it dwelling.
You have to rent a whole single-family dwelling unit, or if you rent a portion of your home, you become a boarding house, bed and breakfast, multi-family dwelling.
So do we just strike the word nightly, Chris?
We just get rid of or a portion thereof. And then you wrote lockout unit. I don't know what a lockout unit is.
It was in the recommended definition from, that one company, the lockout unit, and I don't know what that is. I think we gotta, I wanted to leave it in there so we figure it out before we got too far. into
Okay,
this.
tell me where lockout unit is.
It's
I'm gonna say that.
First page on number 3.
Oh, okay.
So that could be, I mean, depending if we don't need that, obviously that could just be short-term rental showing the rental of the dwelling unit for less than 30 days to a single person.
I would go in an entire. Do you do a single family dwelling or?
So
the
that's
dwelling
like-
unit, like,
It's like a portion of the unit, it looks like.
well, that's the thing, that's not permitted in our code, right? Or a lockout unit is part of a home, like an accessory apartment.
I guess it could be. It looks like this might be considered an accessory dwelling.
So if a house has multiple dwelling units in it, like we have some homes in the lake that have the house and the garage, which is a dwelling unit, I could see them renting the garage, but if you rent a portion of a home, you're not a home anymore, you're a multi-family dwelling.
Well, we don't allow more than one home on a parcel anyway.
But
so
we
it
have
would
a lot.
vary.
We
have a
So,
lot.
but, right, but we have them, so.
You, in most areas, except for the RLD, you can have an accessory dwelling unit.
No, you can have an accessory apartment within the existing dwelling unit.
What's our definition of B and B? Is more than 2?
Three is a three.
3 to 5, after it hits 5, it goes to the Department of Health.
So the thing I have a problem with is single person. So if you have a couple, it doesn't apply to you then, right?
Well, that's again, the wording, the specific wording. We have to, I looked at that too. I was like, I wonder if there's, or, you know, how does that, pertain? Now, usually though, when you do rent like an Airbnb, it's to a single person. There's one person that is filled out. And I've done it many times for BBRO or whatever. There may be 6 people with me, but it's in my name. So I don't know what it's just like a hotel, right? You check into a hotel, you can list a couple names, but the reservation is under one name.
The registrant.
Right.
Yeah, but the definition for bed and breakfast and hotel are totally different than short-term rental, right?
But I'm just using it as an
Yeah, I
example. When
understand
you
what
go
you're
to
saying.
rent something, it's always to an individual. There's one person that's responsible. It's on the hook.
You can say how many people are with you. Yeah.
So, okay. That's an easy fix there for number 3.
Now, another thing that I had a little kickback on it, was approached, is on the short-term rentals, is some of these people only rent them maybe for a week or so to, generate some income to offset their taxes. And they were wondering why they would have to pay the same fee as somebody that, rented it 6, 8 months, a year, or whatever.
Well, how are you gonna split it up?
I don't know.
You charge them more if they have more rentals. It's a real, talk about pain in the ass.
Well, the local law doesn't get into that, so don't worry about it for right now.
If they're gonna be in
So
the
if there's any
rental
problems,
business,
just say,
Well,
talk
it
to Doug.
says-
pay the
It
fee.
says in the local law that the fee would be prorated and the fee would be established by the town board, which is true. I mean, the fee may be $20, it may be $100, it may be $1,000, I don't know.
How,
Keep it simple.
how the heck are you going to, Chris, you're gonna know whether they rent it 1 week a year or 10 weeks?
Doesn't matter, as long as they register, someone complains, we have probably 3 to 4 complaints a year about short-term rentals, so this at least give us a venue. Looking at it.
Do you have any comments, Bob? I know you're disadvantaged because you don't have what Doug passed out to us, but you can see see it on.
I'm gonna, I think up to speed.
Chuck under?
Chuck is on there.
Okay. How about you?
Morning, guys. Morning, fellas.
Good morning. Do you have any comments on it, this short-term rental?
No, are you guys reviewing the same draft that we looked at last month, or is this an updated version?
This is something completely different to a large degree.
Oh, okay. Was it sent out for everybody to look at?
No, Doug prepared it and gave it to us today, so.
Okay.
Right up.
All right. Well,
It's very similar though to what you'd seen before, except with a lot of those deletions that kind of we had talked about at last month's meeting, just to simplify it and make it more of a registration as opposed to permitting.
well, I guess as a result of this meeting, you'll be sending out another draft, so I'll take a look at that when it comes out.
And also, it's a lot shorter than what we've looked at before.
That's good.
Okay, where do we go from here?
We'll, obviously, you can email it out, but, start the process of creating a local law and take it to the town board, set a public hearing, all that happy process.
What's your timeline? I'm just thinking for Chuck's benefit and the rest of us that just saw it.
Oh, you have plenty of time, so
Today to take a look
at the October meeting, we'd set a public hearing for the November meeting, so I mean, there's plenty of time to provide feedback and stuff.
Have you seen this before, Chris?
No, this is just,
You haven't seen any of it?
it's the
No, but I
same.
mean,
Okay.
it's a quick read. It's the
Yes.
same as before, but it gets it down to just registration and it gives us a tool to shut them down. Kind of
Keeps
thing.
it simple.
Yeah.
Well, you, John, do you have any comments on it?
No.
What are you looking for? What are you thinking in terms of finding the STRs and registry? Is this, do you think the town will do it, or you use a third party?
I don't know, probably a third party, but I wanna look at that, and we need to get some quotes and that kind of stuff, and just look at that a little bit, but it's pretty simple, it's just the registration, we'll see what it is.
So in other words, you get this in the books first, and then you're going to implement it after that, right? Through action by the town board, right? So do we want to vote on this now to move it forward? Because we won't be meeting again before town board meets in October. With the changes. Definitely. Moved. Is there a second?
I'll second it, but again, with the caveat that we actually read through it and we, just
Right.
it'd be editorial suggestions only. I think the thrust of it, we're in agreement with.
You got a motion and seconded on the moving it forward for the short-term rental and the changes that will be made. Is there any discussion? If not, all those in favor signify by saying aye.
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 Opposed, no. Okay, carried. Now, the next item is the,
Can you update me where you guys are at with that, because I'm not sure I understand where you guys are at with that, and then Terry, I don't know, maybe just kind of give an update to what we experienced out there with one of these big properties too.
Well, yeah, one of the properties that has been under discussion most of this year and last year, and was Curtis Road. Town did go out and mow down the 3-foot high field that was in front of the house. Couldn't get up close to the house, but only part of the process was completed. The mowing was done with one of our larger pieces of equipment, with the idea of going back and getting up closer and knocking everything down and cleaning up the lot, but that part remains to be done. It would be good to get another mowing in before the end of the year, just to keep this thing knocked down, but it's one of those items. It's not number one on the list of priorities for highway department to take care of. So I've been asking Jim to take care of it, and also to report back what the costs were, because we were going, the intent was to take those costs and, you know, put a lien against the property, so that when the property does eventually transfer, that, you know, we would be compensated for, you know, all the time and effort we put in. But I don't think that that's been assembled yet either, so perhaps because the job was never completed thoroughly, I don't. That's a discussion I had to have with Jim.
I think in answer to your question, Doug, some of the issues that certainly I raised, and I think others raised, were some of the issues with the bond requirement of a financial institution, the forfeiture of a fee to be taken out of the bond from a financial institution, and, you know, how that financial responsibility, or let me say it differently, that this financial liability was any different for a financial institution that foreclosed on a property versus a property that had just been abandoned and not maintained properly to begin with, and not having them have any financial liability or bonding requirement. And I'm just working off of memory now. I think there were a few other issues. I don't have the benefit of having my paperwork here in front of me, but that seemed to be a concern that we shared, I think, at this committee.
That and the getting some institution to actually pony up.
Yeah. Right.
You know, they've been ignoring Chris's, you know, requests for them to take care of this particular property for years now. And how you get somebody to actually commit seems like a stretch to me.
Well, there's actually a New York State law that actually gives us the teeth, that actually says permits a municipality to either compel a mortgagee to either complete a mortgage foreclosure proceeding or to issue a certificate of discharge of the mortgage. And that was signed by the governor. So like in this house on Wells Curtis Road, truthfully, we need to go to the bank and say, listen, either begin the process and foreclose it and take care of it, or discharge the mortgage.
So I did speak to the bank several times. They will not speak to us. They won't tell us or talk to us about the property.
But then that just becomes, we file, we begin the process of filing, and yes, it goes through the court, but then it moves it forward.
So New York State building officials, we actually are working with a couple, a senator and assembly person too. There's a bill that just went to the assembly, passed the Senate, to treat unpaid fines for building code and fire code violations, unpaid real property taxes, and propose a tax lien and stuff. So,
But there's already laws on the books that essentially do that. The Zombie Property Remediation Act of 2019 that was signed by the governor in November of 2009, December 18, 2019 is what I'm reading.
Oh.
So this is a recent one.
That's even more recent than the one we looked at before.
And there's tons of municipalities that already have, that have these, and that are actually even requiring the banks to post the surety. You can actually do a search through E-code and that search. So I'm not suggesting that we need the surety and all that stuff. That's more of a headache, honestly, from a financial standpoint. But we get a situation like with this house on Wells Curtis Road, and we're letting it essentially fester. We're enabling the mortgage company. We've got to put our foot down, whether through our town attorney or whatever the case, because according to the governor's legislation here, they have to either act on it or discharge the mortgage and move on.
So I issue a violation. They don't address the violation. I issue tickets. No one shows up to court, or
Well, have we issued a ticket? Because
I've done this twice already. Yeah.
Yeah, but has anybody, so we
No one,
issued a court
no one
appearance
shows
ticket,
up to court.
and so nobody showed up.
Yeah.
So then the judge found in our favor?
No, it just,
You should have a default judgment then.
Yeah.
If they don't show up.
And in which case, I guess I gotta talk to the town attorney, and then if need be, we take it to Supreme Court.
Okay, then we need to talk to the attorney because they're kind of unwilling to do anything when no one shows up.
Well, and that's also one of the issues that we're having with our town court. They want all these issues to go before Supreme Court, but that's fine. We can do that.
Except for them, it's gonna cost you more money.
It does, but then you have a situation like this house that, what are we going, the third or fourth year like this?
Yeah.
It's ridiculous, and then just,
Well, those costs can also be rolled into. I would think,
absolutely.
all
And it
of
actually
that.
calls for, the governor's legislation calls for the municipality to be made whole on that, so,
The last time I finally got a hold of the company that the mortgage company hired and they mowed it once, they put it up to bid and they mowed it once and I kind of dismissed it from the court.
In that zombie property law, isn't there also something that like it only applies to banks who originate like a certain amount or percentage of mortgages or something like that?
I don't see that in this one. This one is from 2019.
And the older one says $500 per violation per property per day. We
But
start putting,
they don't set the violations. We set the violations of violation of uniform code.
this is in again, the
Yeah.
2016 statute.
It says
They're
add
we
section
gotta
13,
get tough and
adds a new section 1392 of real property actions and proceedings law, which authorizes local governments to commence judicial proceeding in courts of competent jurisdiction to compel mortgage to either complete the mortgage foreclosure action or to issue certificates of discharge for the mortgage for the properties that have been certified as abandoned property in proceedings law, section 1971. So I think there's a step that we're missing, that we have to declare that it's basically an abandoned property. I think we have just cause on the one on Los Curtis, and then we have to begin the process in court.
we did try and talk about the difference between foreclosed, abandoned, and neglected. There are some properties that are just neglected that are owned by somebody perhaps with no mortgage and no foreclosure. So if and when we get around to enforcing, we should look at the neglected issue too.
So I guess my question really at this point is, I still wonder, and I know we've kind of gone back and forth on this, but if we need a local law with this new law that's in place, and what the real clear process is, because this stuff,
You familiar with the new law?
Not familiar with new law. I mean, I'm
Okay.
familiar with our process, but so we take it to court and they don't show up and they order a judgment. That's the point where things end, kind of.
well, that's where it ends for you, but
Yeah.
that's where it picks up for me.
That's what I'm wondering. That's
Yeah,
how
so that's where it then becomes a legal proceeding, and we either file a lien against the property, or basically we get the property by default, we turn around and sell it,
So maybe that's just our process now. I just say we hit this point, Doug. Can't go any further in court.
Right.
I mean, we can, every day after the court judgment, I can issue another violation and just stack them on top of each other.
So I guess send me an update on where that one in particular is.
The update is we haven't taken it to court this time. Last time we took it to court, they did mow the lawn because we got a property maintenance company, but they told me the property maintenance contract ran out in January.
Yeah, they mowed it that was last year, 2019.
Yeah.
So we did it this year, the town did it.
Yeah, we did it.
It
But
sounds
you
like,
had plenty of, did you ever receive any kind of response from them
No,
this year?
just phone
sounds like we
conversations.
don't need a local law. really.
I'm not
It's
so
like
sure
that.
we do with this thing, this 2019 zombie. Just forward me their contact information. I'll talk to the town attorney.
It's the mortgage company online.
Yeah, but just forward me whatever you have, whatever you sent to them and stuff.
Just phone conversations. Honestly, they will talk to me for 10 minutes and say, we'll get someone on it.
All right, then send me the contact information. Okay.
3
So-
hours on the phone to get a hold
I
of
believe
someone.
it. I believe it. And I don't, Chris, are there any others right now? I mean, I'm still wondering if we really need something with this law that the
Right now,
government
no one's
signed.
complained. There's one on Middle Cheshire, which she's mowed here and there and stuff.
Right, we have that option. So.
I don't know.
That was the other part of our conversation, Doug, was that it seemed like we already had ordinances in place to to address properties that were not maintained properly. So if there was a septic issue, we have an ordinance for that.
Oh,
Or if
yeah,
there
well,
wasn't,
we have everything ready in place.
that's what it sounded like, so that we questioned whether we really needed this also.
Mhm. Well, I think based on what I read that the governor had signed last December, and sometimes it takes local municipalities a while to catch up with those things, I think there's some teeth there that the banks should be scared of, that they need to do something or they're gonna lose their basically hook in the property.
The dilemma is, and I'm guessing that's what Chris ran into, is that banks no longer hold out the mortgage. They bundle and resell and resell and resell, so you see the foreclosure notices that somebody's acting on behalf of this and then on behalf of that and so on. To drill down as to who really owns some freaking
No,
mortgage.
we did find out, I called the county, he told me, not house.
Yeah, who's-
And he got a hold of who the mortgage company is, they sent me the information. I called the 1-800 number, got through 5 people, sat in the line, and they're like, well, we can't discuss the mortgage with you. I'm like, well, here's the situation. Oh, we'll get someone on it. And
But the other thing is that's going on this year is the governor's executive order is extended through December 31st now. You can't commence any action on anything like this. So this year we're out of luck because of COVID, but then going forward for next year, there's no foreclosures, there's no nothing. His executive order allows all that to stop. So I wouldn't do anything on this one right now. There's too many questions.
So we spent a lot of time on stuff that we didn't need to.
There's a lot of questions on this one. And, you know, like this thing about this law that the governor signed in December of last year, that was the first time I'd seen that when I started researching it.
But we didn't see, we hadn't seen it. But we wondered why the 2016 law hadn't been enforced.
And this was a new law that was specifically designed to fast track Zombie Remediation Act.
they had a lot of problems in like Albany and that area, with whole streets being placarded and everything.
Sounds like you solved all the problems.
I don't know about that, but all right, what you guys got?
Nothing, we don't need to do anything anymore. We can disband the committee.
Let's go back to your cave and be okay.
Well, those are 2 items we had on the agenda for today, due to the fact that we figured it was gonna be time consuming for them.
Well, and let me just mention, so there's a couple things I know that are gonna be coming at you guys, and Gary, you and I touched on this. So obviously we talked about short term. Myself, staff, and our Parks Committee, we're working on a complete rewrite of the Parks section of town code. So that's gonna be coming to you guys eventually, probably not for a while still. That's probably gonna need another 30 or 60 days. So I would say that's probably, you're looking maybe December, January before you're gonna see that. Obviously, we've been talking with the Labella. We have a project team working on conservation subdivision. Some of you are involved with, so that'll be change of town code, conservation subdivision section. We've got form-based code. Eric, I don't know if you want to touch on that, but I know there was a draft that went out, but we got form-based section of code. And then
Tiny homes.
beginning a lot of questions about sureties, process, section of code relating to sureties, whether or not they're needed, effective, whether it could be simplified. I know one of the things, I had a surety that had conflicting numbers on it, and I'm wondering if there can't be a standard for certain things. And so there's a whole variety of things related to
Surety
sureties.
in regard to what?
Like when somebody comes in and they have to get a building permit, they have to post a surety.
And that
whole
was
process.
Okay, now there is no requirement for surety other than landscape, correct?
No, there's.
Most of the time, it's like soil erosion,
Soil
silt fence
erosion,
seeding.
Right.
Sometimes the planning board can also add landscaping to the condition.
Depends on the,
Yeah.
but then the process, and there's different depending on the amount, and it triggers different reviews. And like, for instance, I'll give you a simple, silly one. So right now, Chris can review a surety estimate, a cash surety estimate. Letters of credit have to be done a little different, but a cash surety comes in, Chris reviews it. If it's under $20,000, he can send it to me. I can approve it by town board resolution that, okay, we're gonna accept this $20,000, and he can go ahead and issue the building permit and go on its merry way. We had one last week where, of course, the developer was trying every which way, every loophole to get around it, but it was $27,000. So I can't accept that. So it has to wait till the town board meeting. So again, you know, little things like that, when somebody's giving us cash for a surety, why does it have to wait and go to a town board meeting before we can issue a building permit? You know, some
So can't
things
you-
like that.
Can't you change the rule?
It would require
Or is it
to
a state-
change town code. It would have to be.
Well,
Yeah.
at least
Yeah.
you do it.
Right. We can do it, but that's what I mean. There's a whole section on sureties that,
Is there a requirement for sureties on commercial buildings, commercial properties that are being developed?
it depends what the planning board requires the surety.
Usually
But-
roadways and
Right.
the structures and.
But once the planning board requires the surety, then state law dictates that essentially a surety has to eventually be accepted by the town board in some form or fashion. So,
You know, like the Liquid Meadows, their latest surety they're posting for that last section was almost $500,000, about 400.
Right.
Some odd thousand for
Right.
the infrastructure in the ground and the roadway and all that. So
Right.
some of the numbers are,
yeah, some of
for the
it,
developers,
right.
very large
Well,
numbers.
especially the letters of credit.
Yeah.
That's when you get into letters of credit, and we have the attorneys review it, and obviously the engineering firm and everything else. But these some of these cash sureties, they'll get up, you know, they depend
12
on.
grand sometimes
Yeah.
and stuff like that. But honestly, my opinion, and whether it means anything, is we should not have them because it just slows down the process and stuff. And we've never grabbed one or never used one. And most of the houses we want sureties are on the lake, and we're asking for $1,200 surety when the house is $2.5 million and stuff like that. It's just,
So I'll share with you guys just real quickly. So there was one that we got that I didn't sign off on at first because I had questions, because it was the same company provided the estimates, but it was two different people in the company provided the estimates, and the one person used a figure, I don't remember
New York
exactly what
State
it is,
DOT
but I'm
numbers.
just gonna say it was like 2 cents per square foot for silt fence, and the other one 2 cents linear foot, and then the other estimate from the same company, a different person, was like 50 cents. You know, so that works up to a wide variety of dollar difference depending on how much silt fence and stuff is needed. So I was like, why is there the disparity too? And I had a conversation with Lance from MRB last week, and what he said is they have basically from DOT, they have a chart that they use, and they recommend, okay, from here to here. The one developer that I had a conversation with that did this, that had the two differences, they said it would be so much easier if you would just say Town of Canandaigua, okay, silt fence, we want 25 cents a linear foot, you know, temporary road construction, we want $500 for a temporary road construction entrance. You know, if we came up with a list or adopted a DOT list.
if
so that's
we
what we're
adopted
going
the
to
DOT
use.
list though, so I accept anything over $2 per linear foot for silt fence. DOT is $8 something. So my $1,200, $2,000 surety would be a $25,000 surety.
Right, and that's where we at least need to have the conversation, figure out. But
Yeah,
we
we-
can't replace silt fence for 2 cents a linear foot.
No, we can't.
yeah, would we have to like essentially find out our cost in order to make like what the estimate would be? Because we're saying, you know, if we had to replace it, you know, we go out to bid for these different things.
But let's face it, it would be us replacing it, would be us installing it, and our crews could probably install it and then charge back, right? But it's not like we would go from start and have to put in silt fence entire, more than likely, right? Because we would have already shut it down, or there wouldn't be a permit issued if they don't have the stabilization, silt fencing, and everything else.
And also, it sounds like this hasn't happened very often.
Well, it
At all.
comes up, this issue of sureties comes up quite frequently. I mean, this was the first time I noticed the variation, but this issue relating to sureties and this process, it's a pain in the butt. We have a
Yeah.
whole separate tracking system on the finance side of things that can tell you for sureties, and usually our auditors are saying, oh, look at this, or we had sureties that Chris has been working on to help us clean up that go back, what, 10 years? I mean,
We got rid of most of those.
there was some that we were holding money for.
Well, most of them aren't.
Us having to go out and physically do work.
Right.
No, it's just-
We've never had to do it.
My sentiments kind of go along the way you're saying, Chris, in the sense that it just doesn't make sense to me. So that, you know, if a person is building a house, what are we concerned with? Whether they're going to complete the landscaping or the
So what it is
Utilities?
if everything goes defunct, the person only builds half the house, something horrible happens, we'd have the money to go in to stabilize the site and everything like that.
But you'd want a surety to guarantee the completion of the house, wouldn't you?
No, that would be crazy.
We don't do that.
Well, now, on a public project, if the town was going to do a public project and you put it out to bid, you're asking for a performance bond, don't you? On a commercial, on a public project.
Well, we have, so for instance, like the highway building, when we constructed that, there were guarantees. in
A
place
performance
that-
bond.
Right.
So that guarantees the completion, in theory,
Mhm.
that would guarantee the completion of that building, should the contractor go belly up.
Right.
In theory.
Right.
I mean, there's a whole process that has to be
Right.
gone through to ensure that. But on residential property now,
Mhm.
and I just went through this, and correct me if I'm wrong here, the only thing you asked for a surety from me on was the landscaping work. So
You're
if I
working
can,
in sediment control.
okay.
So, yeah, so.
Yeah, so if I was to get halfway through that project and I couldn't complete it, it's gonna sit there abandoned until who knows when, right?
Mhm.
So the surety now is only guaranteeing that sediment control or that landscaping.
Because the only thing we're concerned about is making sure you don't have a rain event and it turns the lake muddy.
Okay, and if that's what we want, that's good, but that, I just,
Right, but to your point, John, yes, I'd like to think that we would have handled it differently, but let's use the classic example. If the bird cage had been in the town of Canandaigua,
yes.
it would have been a similar situation. There's no real teeth. I think there's some things we could have done differently.
Per code, I could have.
But we don't have a surety in place that we would go cash and then finish the building.
No, but you at least have that performance bond that you can go and,
It's on private property.
But either way,
Not.
there was about
oh,
20.
yes, you're right, because that is a private property. It's not a town project, right?
But
It's
there
not
was like
publicly
20
funded.
code violations.
I know. That's why I say I like to
If the
think
city
that we
really
would have handled
wanted
it
to-
differently, but still, there's no performance bond that we would complete the project or anything like that.
And that's I kind of guess that's my question or my puzzle in my mind is, don't we want some protections like that?
John, the corner of Yerkes and Brickyard, when Chuck and I, the planning board, looked at that, and before we gave them approval, we asked the same question: how the hell do we know whether this is going to be completed? Can't we get a performance bond or a completion bond? And I believe it was Chris Nadler said that we didn't have the power to say we wanted a bond that says it's going to be finished. And this was Morgan when he was in the throes of dilemmas, financial dilemmas. And what we did get is we got a letter from a bank saying, yeah, he's got the money, or he's got the commitment, right?
Well, that would be a letter, you'd get a letter
It
of
wasn't a
credit.
letter of credit. It wasn't that good, right?
It was, don't worry about it. We
Yeah,
got the money.
don't worry about it. He's a good guy, was he? But I felt stupid approving a project. I don't know, has it even started at this point?
No, phase 3. The funny thing is all the utilities and everything are underground there.
Yeah.
Well, that was a
But I,
they've been there
like
a
John,
while.
I said, you know, here's a guy where we should certainly have it, and was told I couldn't ask for it.
Well, the townhomes, those all got completed, but you're talking about the apartments there. But again, the ground is stabilized, the grass is growing, there's no runoff. I mean, it looks goofy with pipes sticking out of the ground, but.
But let's say he got it framed and this dilemma arose.
Well, then it would end up being a question of whether it's a zombie
No,
property.
it would be a code violation. The building permit would expire. I wouldn't renew it. I take them to court and we can hit them for $500 a day until they stop and clean it up.
Okay, if you don't collect it, it doesn't make any difference.
People like
And you're at the back of the line as far as the creditors
Right.
go.
Well, I think that this conversation certainly brings up the point that we ought to have more conversation.
Correct,
about
right.
The surety.
That's that whole
Ordinance.
process and everything, right?
Is the question of not being able to assess a performance bond because we have nothing on the books, or you can't do that? Which,
Well, I think that I would have to again dig into this, as John said, a little bit more. I think that we could require a performance bond if we had something on the books associated with it. But I think then the question also though becomes, do you want to? I mean,
It would
then it
make a
becomes
hard
so
for people.
expensive for the person to complete the project.
I mean, I want to build a house in 5 years. Come on.
Well, then the question becomes, do you do it for multifamily type housing versus single residence type housing, or maybe
The odds
just,
are somebody's gonna get a mortgage for a single family.
right,
And it's not gonna break ground until it's, at least the construction loan is in place.
right.
So there's a much less risk than
Yeah.
when you're talking about an apartment project.
And then, so then in terms of ordinances and local laws, the other one that I think is probably gonna take you guys a little bit of time is form-based codes. I mean, by
What
the
is
time
that?
we hash that around.
Excuse my
Why not?
ignorance, but
Yeah, I'll go over it. So, the town completed the Uptown study in 2018, May 2018. And then started moving towards the first phase of that, which is creating form-based code standards for that Uptown area. It was initially gonna be the entirety of the Uptown area, but due to COVID, they had to kind of shrink it down. So now it's like the 332 corridor and the corridor along Fire Hall Road. Do you know where I'm talking about?
Mhm.
So, form-based code is different from our traditional Euclidean zoning, because Euclidean zoning kind of segregates the uses. You're allowed single family here, you're allowed industrial here, you're allowed commercial there. Form-based code says generally anything's allowed as long as it looks appropriate to like the public space, the roads, the sidewalks, stuff like that. So it has to meet certain design requirements, then otherwise you can kind of do anything. With some restrictions or some prohibitions on adult uses generally. So where we are in the process right now, we've retained Labella to do, or excuse me, not Labella, Bergman to do the like a draft form-based code. We have a draft of the portion that covers 332, but not Fire Hall Road just yet, as far as what the standards are. And it was supposed to go to the Economic Development Committee this month, and I'll send it to everybody after this meeting. But again, it's so that, the purpose anyways is so that developers, we get a greater mix of uses. It's better for walkability, mobility choice. It's better for economic development generally. But that's kind of the goal of that area, to accomplish our uptown plan, knowing that community commercial zoning district, the RB1 zoning district, and all those ones that are in that uptown area don't really do what we'd like to do in that area, requiring big lots, big setbacks,
Generally,
mixed uses,
denser usage.
denser mixed uses.
Well, they, go ahead.
you know, it's kind of more architectural and
Yeah.
nature than mathematical Euclidean, you say,
Yeah,
setbacks based on numbers.
it's essentially, it's something more of like performance based. Like performance zoning is like everything's allowed except for certain nuisances or whatever. It's kind of like that. As long as you don't harm the people around you through various nuisances or architectural design, you can do it. Accepting that different uses aren't necessarily bad.
So related to the form-based code, only because it covers some of the same area, is the mixed use overlay. That's a separate section of the code. There's some things that could be cleaned up in terms of that process. But let me give you a classic example of that one. So we actually got used as an example of what not to do with our mixed use overlay. Because our mixed use overlay actually only allows for a single use, even though our intent was to allow multiple uses. So there's some things that need to be cleaned up associated with the mixed use overlay. That's certainly something that you guys can take a look at. But at the same time, form-based code, my guess is MUO1 is probably going to go away because it'll now be the form-based code once that gets adopted. But we'll still have MUO2 and 3 that I think could be looked at. And then the other thing, and this came up again just recently too, and I've heard this before, our process with the MUO currently requires an applicant to come to the town board and say, basically, town board, do you believe that this concept is fitting for the area or for the parcel that it's, being proposed for? The town board may request an advisory report from the planning board. If so, the planning board provides that report back. And then the town board says, yes, generally, hypothetically, either yes, we agree, or no, we don't, and it kills it, or yes, we do agree that this generally is in keeping for the area. Then what happens is the project then goes back to the planning board. The planning board, the applicant has to get preliminary overall approval, preliminary site plan approval, and then it comes back to the town board the last time for the rezoning, any which point in time the town board has the authority and the power to say no and kill the whole thing. But from the developer's perspective, and I've heard this in the past, and most of our developers have been pretty good about working with us, they get concerned that at any time after all that engineering work and everything that the town board could change and the town board could say no after they've invested all those thousands of dollars in the engineering and everything else. And then we also just heard again, Eric and I were in a meeting last week, and I said to the developer, well, why don't you just go ahead and hurry up and get us basically the preliminary? And he said, well, your requirements for preliminary are so cumbersome in the town of Canandaigua that I basically have to design the whole project. Maybe you should relook at the section of code that details what's needed for preliminary approval. So I think I bring it up, I don't know exactly what's going on, but I've heard it enough over the years that it pokes at, I think there's an issue there that we could probably clean up and make better or make more efficient.
It is cumbersome.
Certainly it could take a lot of the time out, and I'll step back, and
Right.
each of those is at least a month.
Right.
Back and forth, so
Yeah.
there's 6-8 months right there, let alone the cost.
Right.
And this is in an area that you already said, this type of growth is appropriate generally.
Right. Yeah.
Sounds like that's something that we should make a priority.
So we got a couple things coming, I think, for the ordinance committee to think about and work on. Gary, I don't want you to be bored.
Be nice to get that list from you. Look from here, it looks like you got like a.
Right.
Oh, so every single Monday at 11 o'clock, I have a meeting with my internal office, and these are all the things that I got to follow up to make sure that they got done and things to do. But number one is the ordinance committee, and there's like 8 things there. So
I don't know if I wrote down anything.
Send the list, right?
I will. I'll send it to you.
Put them in his dartboard at home.
And don't change the ground rules. Is there anything else that we want to discuss today? It's close to 10 o'clock. Anything Chuck or Bob want to?
Nope.
I'm good.
What would the committee like to have on the agenda for the November meeting?
Doug's list.
Just part of it.
Well, we wouldn't have anything, I wouldn't think, with conservation subdivision yet. For the form-based code, we do have that draft. I don't know. I think the original plan for it was that the Economic Development Committee was kind of doing that and then would send it to the Ordinance Committee for review, or?
Well, technically, that's a project team, so it's got to go back to CIC. That was all part of the CIC. So the CIC, before it really gets to start the town board process, we got to just wait and make sure.
Okay, so don't put it on the Ordinance Committee yet.
I mean,
until
you could start talking about it. I know I won't have parks ready for you, but you could start talking about it and be familiar with it. But then you've got, well, the MUO and the preliminary that we talked about, and then there's the question about sureties. I don't know what the answer is to that, but there's a question.
Yeah, because some of these things we, need to probably get our feet wet a little bit on them because it's going to take quite a few amount of time to move it through the
Well, that form-based code was rather lengthy, I think, and took some time.
Okay, then you'll,
Weren't you guys working on something for off-street parking? That's,
Been
Chris
passed.
Oh, yeah,
got
Chris
that,
Gather
yeah.
has it. He says I messaged him on Friday. He says he's gonna have a draft for the town board to set a public hearing in the October meeting for November.
and then we also have the local law for the NRI that also, be careful about setting too many public hearings for that one.
so we're pretty well set. We can have, our next meeting will be November 2nd. And Eric sent something out to you in regard to, what we're going to be discussing.
I think he'll send me or the whole committee that draft.
Oh, yeah, that's actually.
Okay, then, entertain a motion to adjourn.
Sure.
No, thanks. Thank you,
Thanks,
Ben, for
everybody.
coming.
Yes.
Awake?
Hi, fellas.
See it.
Bye now, guys.
Take care.